In this video, we will discuss about corporate frauds. Before getting on to the video, if you have still not subscribed to our channel, please subscribe. If you like this video, please press the like button and then share it to your friends. Corporate frauds, nowadays it is becoming very common. Please note what is fraud we need to understand, and in addition to that, the punishment for fraud is the end objective. Whoever involves himself in the fraudulent activities, they have to be prosecuted and then penalized. That is the objective of the law. Here, fraud is one of the important terminology which was not used in Companies Act 1956. But after the introduction of Companies Act 2013, we have the provisions which talks about punishment for fraud, and it gives the definition of fraud also. And one more other important enactment which talks about fraud and related punishment is the Indian Penal Code. So what is the proximity of the definitions between the fraud as enumerated under Companies Act 2013 and fraud as defined under Indian Penal Code? We need to necessarily understand, because there is a requirement to do a harmonious construction, because for the punishment of the fraud, the criminal courts will have the jurisdiction, that is the special courts which is being set up as per the provisions of Companies Act 2013. Now let us try to understand what is the basic concept of fraud. What is fraud? Fraud means a wrongful or criminal deception. Please note, in the fundamental principles of criminal law, the most important element which has to be, before penalizing a person, before prosecuting a person, which needs to be necessarily kept in mind is whether that particular person has the intention, whether he had the mens rea. That is one of the important terminology. Mens rea is called guilty mind. The person who wants to commit fraud, he should have deceived, in the sense like wrongfully he should have deceived it. That means he should have made the idea, and then with the intention, basically like he would have framed that particular series of activities. So that plays a very important role. First important thing is criminal deception. That criminal deception should intend to result in financial or personal gain to oneself. Please note, there are so many situations where the companies will be formed and the companies will accept the deposits and then the promoter runs away. How many examples of this kind we have seen in the news in the recent past? And the people who have put the money trusting the promoter, they would be coming onto the streets and then they will be protesting, they will file the case. This has become very common. So this is something where if you want to analyze this particular example within the ingredients of the fraud, the person has criminally deceived it, in the sense like a systematic basically like an activity he has set up where he has gained the trust from the public, and then the public has trusted him and then they have deposited in the company or invested in the company, and that particular person, after the money is being deposited into the accounts of the company, he takes all that money and runs away, so that no benefits will be passed on to the depositors as well as whoever has invested in that particular company. This is a classic example which we have seen nowadays in so many corporate frauds which has happened recently in India. And a financial or personal loss to other, correct? If one person is gaining and the other person should end up in loss, that is the basic terminology when it comes to the conceptualization of the terminology which is fraud. Please note, here detailed analysis required to be done, that what amounts to fraud. There are various cases which is required to be analyzed, and one by one we need to come to the conclusion what amounts to fraud and what does not amounts to fraud. If it is coming, basically like we conclude that it amounts to fraud, then they have to be punished according to the provisions. Basically if it is corporate fraud, then in Companies Act 2013 very clearly they have mentioned what is the punishment which is required to be provided for the fraud. Please note, if I have to necessarily analyze the definitions of fraud as per the Companies Act 2013 versus Indian Penal Code, please note you have a detailed definition as per Companies Act 2013. It says that any act, omission, concealment of any fact, abuse of position, whatever might be the situation, with the intention to deceive, or defraud the company itself, the shareholders, the creditors or any other person, the stakeholders, that would necessarily mean fraud according to the definition provided under Companies Act 2013. There might be a wrongful gain or wrongful loss, that is immaterial. There might be a personal gain or personal loss, that is immaterial for the purpose of Companies Act 2013 definition. With the intention to deceive, if any act or omission is being conducted against the company or shareholders, then that amounts to fraud according to Companies Act 2013. But when it comes to definition provided in Indian Penal Code, the intention to defraud and there should be unlawful gain or loss. Unlawful gain to one person and loss to other person. This is most important ingredient for the purpose of Indian Penal Code. But the primary difference between the definition of Companies Act 2013 versus IPC is this personal gain or loss is immaterial when it comes to Companies Act, but it is an important ingredient when it comes to Indian Penal Code. Now, whose responsibility is to identify the fraud? The auditors, the company secretaries, the whistleblower policies, that is the top management as well as the employees of the company, the independent directors, the various committees, the regulatory authorities, all these people are entrusted with the responsibility of identifying the fraud. If any of the external parties as well as internal parties collectively come together and then get themselves involved in the fraudulent activities, then all put together the punishment will be levied. So, fraud is a very serious criminal act for which a serious punishment is being involved, imprisonment as well as huge penalties, which is being basically prescribed for both external consultants as well as to the employees of the company, including board of directors. So, this is one of the important terminology where to be kept in mind, the company secretaries has to necessarily keep this particular provisions in mind before appointing themselves either as a whole time company secretary or starting the practice. If you want to learn more about this particular course, please fill up the Google form which is being provided in the description box below. If you have any questions associated to this particular video, please comment. If you want to know more about the courses offered by Ekcel Academy, please visit our website www.ekcelacademy.com. Thank you.